Hi, my name is Adam Whitmer. I'm the founder and host here at ComplianceCohort.com. This compliance clip is going to talk about inquiries as a factor on the adverse action notice. So I've received this question several times over the years and realized I haven't yet done a video on this. So the question I got specifically this time was a little bit different in regards to listing inquiries as a factor on the adverse action notice. So what the question was is it came in and somebody was asking about inquiries. They understand that on the adverse action notice, you're supposed to list the 4 key factors that affected the credit score, and if inquiries is a factor, then you would list 5. So the inquiries being the 5th credit score. And her question asked this, and then it went on to say this. It said, "It has always been my understanding that if the number of inquiries is listed as the 5th key factor as affecting the credit score, then that is a business decision on whether that factor is used as the 5th factor. It is more important to use the 4 primary factors, and if it's the 5th one, it's up to you whether or not you include it." So that's actually a question I hadn't heard before, so I dug into the original rule back in 2011, because the answer is going to come from the Fair Credit Reporting Act and Regulation B, but specifically we're going to get our answer from the preamble to the July 15th, 2011 Regulation B final rule. So I dug into the preamble, and here is what I found. It said this under number of inquiries, and I think somebody from Europe has written in the CFPB using the inquiry spelled with an E rather than an I, but that's how they spell it in this final rule. They say this, they say, "Several industry commenters suggested that creditors not be required to disclose the number of inquiries as a key factor that adversely affected the credit score if the number of inquiries is not one of the top 4 key factors. In these cases, the commenters said that the effect of the number of inquiries on the credit score is marginal, so that disclosing the number of inquiries as a key factor may be confusing to consumers." So they're saying it's not a big deal if it's not one of the top 4, so it shouldn't be included. Well, that's what the commenters said in the comment period for this from the proposal. So in the final rule, here's what they actually said. They said this. They said, "As discussed above, Section 609F9 of the Fair Credit Reporting Act states that if the number of inquiries is a key factor that adversely affected the consumer's credit score, that factor must be disclosed pursuant to Section 609F1C of the Fair Credit Reporting Act without regard to the numerical limitation. The Fair Credit Reporting Act accordingly requires disclosure of the number of inquiries as a key factor, regardless of whether it is one of the top 4 key factors. Thus, agencies adopt the proposed provision without change." So this is one of those rare instances where I got a somewhat unique question and the prefatory text specifically answered it, almost the exact same question that was asked. Now, as a best practice, I always recommend to use the credit report to provide the key factors that you're putting on your adverse action notice. And these key factors are not your denial reasons, which is something else, but these are the key factors required by the Fair Credit Reporting Act and incorporated in this Reg B final rule. So these are the key factors you're getting right off of your credit report. It usually lists 4, and if inquiries is there, some credit reporting agencies list them together, but some actually list inquiries down below in a lower section. So that's what they're talking about here. Now, let's back up in the prefatory text, and I want to show you what they say about what I just said. They said if a creditor is using a credit score purchased from a consumer reporting agency, the consumer reporting agency is in the best position to identify the key factors that affected the score. Thus, the creditor would need to and absolutely could rely on the information in its disclosure to consumers. So that's what I always do when I'm auditing an adverse action notice. When I get to the key factors, which is at the bottom of the adverse action notice, not at the top, which are denial reasons, which are different, but the key factors affecting the credit score at the bottom, what I always do is pull up the credit report and look for the key factors there. Now, if the key factors aren't there, I also look for the exception notice. In fact, a lot of times that's what I'll go to first, depending on the bank, is to look at the exception notice provided to consumers because it contains the key factors, including inquiries as one of the reasons, usually broken into the clump rather than broken out like some credit reporting agencies do. And the preamble actually goes on to talk about this. They say, in any event, creditors have two options. They can write their contracts with consumer reporting agencies to require the consumer reporting agencies to provide the key factors adversely affecting the credit score. So you can require your consumer reporting agency, your credit reporting agency, to put the key factors right on the credit report. Or number two, you can choose to send credit score disclosure exception notices to all consumers applying for non-mortgage credit. So your other option is to use a credit score exception notice. And in here, they say you can choose to send that credit score disclosure exception notice to all consumers applying for non-mortgage credit. And that would be in the case that your credit reporting agency is not putting that on your credit report. That's a lot of information. Of course it is. It's a topic that I am quite passionate about. So that was a question I received today. Figured it'd be good to share with you in this compliance clip. Now, if you're new to the compliance cohort, we offer a bunch of free training videos just like this to our basic membership. Our basic membership is free. It includes free training videos, free articles, and other resources. We have giveaways. We have a weekly newsletter on Fridays, discounts, and other things. If you're an existing customer, you know we offer that. And we also have additional training programs in our store where we take deep dives into various training programs and topics just like this. So again, thank you so much for watching this video clip. If you're new to the compliance cohort, consider signing up for our free membership. Otherwise, I hope to see the rest of you soon. Have a great day.